Let's talk about another important term that exists in the law. The Fair Housing Law talks about who is covered under this particular act, and it uses the word agent. There is the law of agency. Now, who is an agent? Well, according to the law, it is a person or entity that is empowered to act in place of someone else. In this particular case, it is someone who can act for the owner of the property. Now, that might be the management company, and there's a contract in place. Now, why is that necessary? Well, real estate transactions, and leasing is a real estate transaction, involves a contract. Unless the people that work for the management company or the owner were covered as agents under the law, they couldn't sign that document. They could not bind the owner to that lease unless they were covered as an agent. They were considered under the law to be an agent. The same thing is true in the fair housing arena. Anything that any of the people do who are involved in housing, multifamily housing or single-family housing management, are considered to be agents under the law. And therefore, what they do binds the owner in good ways, but it can also bind them in bad ways. Let me give you some examples. Let's say that you are a caretaker in a building, and you live in that building, and so you've made friends with some people around you. And several people in the building have families with young children, and perhaps there's a pool. And you have rules in the building in which children are forbidden to be in the pool unless they're of a certain age, unless they are supervised. But when you see your friends' children in the pool and they are under that particular age, you ignore that issue. Now, one can say, well, I'm not really discriminating against someone. I'm simply giving a favor or doing a favor for my friend. Well, because you wouldn't do it for every other family in the building, you are considered to be giving different treatment, unequal treatment to those individuals. And they may claim it is because of their membership in a particular protected class. Here's another example. Now, I know sometimes we work very, very hard to keep our communities in good shape. You know, we keep them well maintained and we keep them very clean. And sometimes things can happen that upset us. Perhaps one resident behaves in such a way that they do not show respect to the work that you put in. So you may make a comment to them while you're out doing your work. If that person is a member of a protected class and you use any kind of racial epithet or slur or language when you address them, it indicates that you are not colorblind. You are not racially blind. You, in fact, note in your comment to them that they are of a particular race or a particular color or a particular ethnicity or national origin. If you do that, they may come back and claim to you or to the government that you have discriminated against them because of what you have said. And you have bound the owner of that building in what you have said. It is no different than if the owner had been in your place and said exactly the same thing. That's what agency does. So who does it cover? It covers all kinds of people. It certainly covers the management company, all the employees of the management company. If there is no management company, it covers the manager of the building if they work directly for a management company, or the employer himself or the owner himself. It covers everyone that works on the property. Anyone who does painting or leasing or caretaking or is a porter or is a landscaper or a person that mows the lawn. It also covers vendors. People that you hire with an outside contract to do that work for you are equally bound. Let's say the same situation occurs with someone who's been contracted to come in and do landscaping. And let's say that person has a particular axe to grind or is bigoted against a particular group of people. And he notes children on the site or individuals on the site, and he makes a remark to them that can be considered a slur. He might call them filthy something. Insert the particular race, creed, ethnicity of that particular person in that blank space. And if that vendor makes that comment, it turns out that the government feels it is the responsibility of the management company to only hire people that are aware of the law, that are aware of their agency position and that understand fair housing and will not do so because, again, it's just as if that comment were being made by the owner. Now, the penalties for this are very, or can be at least, very severe. The government would say that if a lawsuit is brought, there may be a shared responsibility. It may be that the landscaper is held responsible for it, the owner is held responsible for it, the management company who did the hiring of that particular vendor is responsible for it, or if it's an employee, that the employee themselves is responsible. And the government, through its various agencies, will enact penalties and fees against all the individuals that are involved. Plus, the individual that was harmed by the act may bring a civil suit. And civil suits are brought by individuals who say they've been damaged in some way. And they will be given the following. They will be given actual damages if they are found to be in the right. They may also be given punitive damages. And I don't know if you're aware of some of the cases that have occurred in our country, but juries have been quite generous. The word punitive comes from a Latin word which means to punish. And if judges and juries feel that the act that was committed was nasty enough, it was egregious, they will make someone pay. The person that committed the act will be punished by the fees that are levied against them. You don't want to be one of those people, and you certainly don't want to put your company in that particular position.